Is there a statute of limitations for the police to lay a sexual assault charge in Canada? The short answer to that question is no, absolutely not. What happens under our system, unlike many states where there are statute of limitations for sexual assault, is sexual assault's a dual procedure offense. The Crown can elect summarily, which means it's a more minor sexual assault generally, or the Crown can elect by indictment. If a charge is laid and the Crown elects by indictment, the police can charge a person from 1970. That's the way our law works. And this applies to many other criminal offenses if for any dual procedure criminal offense under the criminal code, the police can lay a charge from the mists of time going back to the 70s, 60s, as long as people are alive, essentially. So that's the law, and this applies, for murder, for all sorts of serious cases, and even some minor dual procedure cases like a break-and-enter, more minor, I should say. Break-and-enter is not minor, I didn't mean to minimize it, but even an assault charge, simple assault, the Crown can elect an indictment and charge a person from 20 years ago. But it does present a lot of difficulties when I call these historical charges, and when the police say lay a charge from 30 years ago, memory's a difficult thing, reliability, accuracy, and it's very difficult for the prosecution to prove those cases. Have I ever seen a conviction? I have, but it's difficult. I have defended many of these cases over the years, older cases, and even recently I've been, defended about 3 of those type of historical cases just within the last 4 years. And I don't recall ever losing one in my career because I'm not saying necessarily that the victim wasn't telling the truth, but the memory is just not reliable. And once you start cross-examining, they can't really remember incidents well. And the judge has to be convinced beyond a reasonable doubt, so you're testifying from something from 1972 when you were 6 years old, and it's not easy to prove, let me put it that way. So that's it. Now, there are commentators who critique this. I'm not in that camp, by the way. If someone committed a criminal offense, they deserve to be prosecuted. And this coming from a defense lawyer here protecting people's rights. I'm a law and order person too. I don't think that criminal defense lawyers aren't law and order people, and we're just doing our job, or I'm just doing my job. So yeah, no, in that context, a lot of victims, or some victims, will choose to lay a lawsuit or start a lawsuit, I say, which is much easier to win because that's just balance of probability. But one strategy that I've seen for victims to use who are truthfully abused will be to lay a criminal charge and use that as discovery, if you will, to lay the grounds for the civil lawsuit, because it's much easier to get a settlement, negotiated settlement on a civil lawsuit, because it's just balance of probability. So that's the law, that the fact that there's absolutely no limitation in Canada for criminal charges. I totally agree with that. You'll get other opinions, and certainly the States takes a different approach in many states to that issue. Thank you for joining me today on this topic. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.